Oh my God. Just when you think that the Kamala Harris-Joe Biden Department of Justice defending the ATF could not get any worse and screw up things even more, guess what? It looks like DOJ said, hey, ATF, hold my beer. Check this out. That's right. You're not going to believe the crazy, terrible material error that the Department of Justice and the ATF made before the U.S. Supreme Court, and they got caught. Let's talk about it when we get back. It's shocking. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed, What the 10/7 Attacks Teaches Americans About the Right to Bear Arms. Oh boy, someone's in some hot water, and it ain't me. That would be the Harris-Biden Department of Justice, the Solicitor General's Office on behalf of Harris and Biden, and the ATF. As you may recall, next week, before the United States Supreme Court, on October 8th, there is an oral argument in the VanDerStok versus Garland case involving the brand spanking new rule adopted not by Congress, but by the Department of Justice, and specifically the ATF, that redefined what a framer receiver is. I'm going to tell you briefly how they changed the rule, and then I'm going to explain to you the shocking mistake that was made by the ATF and the Department of Justice in front of the Supreme Court, and how they got caught, and how they had to go mea culpa to the court itself. But just to jog your memory, the issue presented in VanDerStok is this redefinition of what is a framer receiver, which broadened the definition of what is a framer receiver, and by extension, broadened the definition of what is a firearm to the point where parts, gun parts, and weapons parts kits somehow, for the first time in American history, have become firearms that require, for example, the running of a NICS background check before you can acquire one, and the acquisition of a federal firearms license by someone that wants to sell gun parts. Now, just to jog your memory, under the definition of the federal definition of firearm, it is something that, without getting into the specific details, it is something that causes the launching of a projectile by virtue of an explosion, okay? But more importantly, for the purposes of this video and the VanDerStok case, it's the second part of what constitutes a firearm, and that is a frame or receiver of any such explosion, driving forward projectile weapon, a frame or receiver. So up until this final rule adopted by Joe Biden and Kamala Harris to make it harder to acquire guns and gun parts, the way the ATF would do it, and you're going to see how this shows the screw up here, the ATF would look at a particular item and ask themselves, what has been done to this item up until this moment in time? Is this a frame or receiver now, based on where this item is today, and what's been done to this item up until this moment in terms of like milling and drilling and whatnot? Because Joe Biden could not expand the definition of firearm to encompass what he likes to label ghost guns, which are unserialized firearms or privately made guns and the parts that go into making these, the ATF redefined what is a frame or receiver by expanding the definition to include things that could become frames or receivers. And the sleight of hand is this. The ATF went from looking at what an item is and backwards prior to that point in time, what's happened to the event, what's happened to the device up until this moment, what's happened to the object up until this moment. And under the new set of rules adopted by Harris and Biden, they look at the object today, and instead of looking backwards, they now look forwards into the future and say, could this object that I've got my grubby little fingers on, could this object I have my grubby little hands on potentially become in the future if I do some more milling and drilling and manipulation of it, or fabrication of it, whatever? Does this have the potential to become a frame or receiver in the future? Do you see the sleight of hand? It goes from looking into the past to looking into the future. Now, of course, what's terrible about this is that Joe Biden and Kamala Harris are pretending that this is no change in the law, but this is all utter BS. And here is where the Department of Justice, the Solicitor General's office, and the ATF got in big trouble to the point where they had to write a mea culpa, please forgive us, Supreme Court letter to the Supreme Court. Specifically, in order to make the case before the Supreme Court that the rule change that the Harris-Biden administration and ATF did was actually not a change. Do you hear what I just said? Their argument is literally to combat this alleged new dangerous phenomenon of the rise of ghost guns. This is their argument. The ATF went out and has decided to do more of the same and simply clarify what they've always done. See the sleight of hand? They're pretending that they haven't done anything different, and the rule that they're applied or created in 2022 is the same thing they've done for decades. Now, this is utter BS. But to show, to make this argument, what the ATF did in the Supreme Court turned out they made a false statement. Specifically, the government incorrectly asserted that the ATF did not reclassify a particular polymer 80 product because of a change in the rule, but because polymer 80 had changed the product. You hear what I just said? The ATF said that they had classified one item in 2017 as not a firearm, and then they classified the same item in 2022 as a firearm. But then the ATF tried to explain this inconsistency by saying that the product in 2017 by polymer 80 was a different product than it was in 2022, and that explains why in 2017 the ATF said that product was not a firearm in 2017, but in 2022 it was a firearm. But it turns out that that was factually false, that the product in question by polymer 80 never actually changed and has never been at any point in time a frame or receiver, because both in 2017 and in 2022 that product, that polymer 80 product, required a substantial amount of additional machining to be done to the product in 2017 and 2022 in order for it to be able to function as a frame or as a receiver. Now, what happened based on the ATF Department of Justice submission to the Supreme Court is they made a false statement about this and got caught. And now, after getting caught by the VanDerStok plaintiffs, they had to come forth and say, we're sorry. Here is what the letter says to the U.S. Supreme Court, apologizing for this terrible mistake that they made in their statements to the court. I am writing to correct an inaccurate statement in the government's reply brief in this case. The reply brief stated that polymer 80 PF940C products ATF reviewed in 2017 and in 2022 were different because of the distinctions related to the trigger pinhole, trigger mechanism, housing pinhole, and material in the front or rear fire control cavity. However, after the brief was filed, bing, 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 listen carefully. After the brief was filed, counsel for the VanDerStok respondents drew our attention to a 2022 ATF classification letter that was not previously cited in the briefs to this court, but that is included in the district court record. This is going in a bad direction for DOJ. They're saying that they made a statement that says that these two items were different products, one in 17 and one in 20. They said because of the machining. Now they're admitting that they were wrong, and most importantly, they're saying that they actually had the evidence of this in their possession because it was literally in the court record compiled in part by the ATF itself. So they're basically saying we had the information and we didn't cite to it and we got it wrong. Let's see what they go on to say, how they try to get their way out of this one. After reviewing the 2022 letter and consulting with the ATF, we agree that the statement in the reply brief was incorrect. Both the 2017 product and the 2022 product lacked a completed machined or index trigger pinhole and trigger mechanism housing pinhole. And both products had material removed from the front or rear fire control cavities. We apologize for that error. Wow, this is very embarrassing. You see, the Solicitor General's Office of the United States, who wrote this letter, are supposed to be some of the finest lawyers in America, experienced Supreme Court litigators who don't make mistakes. They're supposed to be known metaphorically as sometimes the 10th justice, which means they're supposed to look out for the integrity of the Supreme Court itself. And the fact that they made a major material boo-boo and then had to come forth and apologize for it is quite embarrassing. There's no doubt that the Solicitor General's office is extremely embarrassed for having to do this. And they're probably very angry with the ATF for not bringing this to their attention. But it gets worse, because what the ATF and the DOJ and this letter goes on to say is they try to save face. Because then they go on to try to say that, well, yes, but they're still technically different products. This is what they write next. The 2017 and 2022 products were, however, materially different in another respect. The PF940C product that ATF purchased and classified in 2022 included additional components and materials not contained in the Polymer 80's 2017 submission. And then they go on to try to save face. But guess what? That blows up in their face too. Because after this letter was written, the lawyers for VanDerStok and the VanDerStok respondents responded, pointing out, dirty, 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 no, very bad. Here's what they have to say in response to this letter from the Biden-Harris Department of Justice that wrote that letter on behalf of the ATF. Let's see what the VanDerStok lawyers have to say about that submission by the ATF to the Supreme Court. The government's letter implicitly acknowledges that the PF940C frame precursor that ATF classified as not a firearm in 2017 had the same machining as the PF940C frame precursor that ATF classified as a firearm in 2022. Both classification letters assessed the machining on that product with divergent results. You see, that was the problem, that the ATF is trying to say that they're being consistent here, but again, they treated the same product for all intents and purposes in 17 as not a firearm, and then in 2022 as a firearm. That's how they classified it. But then they go on to try to argue to the Supreme Court that they are being consistent and always have been consistent with their classifications. But this simply proves that's not true. This letter goes on to continue to attack the DOJ ATF by pointing out that their attempt to distinguish between the two in this letter after the fact is not going to fly either. Here's what they write. There is no mention made in the 2022 classification letter of using the locking block rail system or rear rail module for indexing. Polymer 80's instructions for machining the PF940C likewise do not suggest using these items for indexing, and it is not readily apparent that it would be feasible to use them in that manner. Furthermore, nothing in the 2022 classification letter indicates that the result would have been different if the PF940C were not sold with a locking block rail system or rear rail module. And then it goes on with the final shot pointing out just how crazy the ATF submission by the Solicitor General's submission on behalf of the ATF has really got, and how this is just killing their credibility to have any chance to win before the Supreme Court on behalf of the government. This is where the letter basically wraps up. In any event, regardless of whether the PF940C can be machined to accept a locking block, the salient point is that it cannot accept any locking block, including that associated with the locking block rail system, unless and until machining operations are performed by the end user. And that's the key, folks. The ATF, again, changed their focus from looking at the item and then seeing what happened to it up to that moment in time to looking down the chessboard to say, we're looking at this item and asking ourselves, can this at some point become a frame or receiver? But that's an absurd way to do this, right? Because that's like looking at a child on a playground and saying, hey, that kid could become the president of the United States, and therefore we should treat him as the president of the United States, or that kid could become a great NFL quarterback like Tom Brady, so we should treat him as an NFL quarterback, Tom Brady, and so on and so on. It's simply stupid. The question is, what is this item? Is it a frame or is it a receiver? Period, full stop. It doesn't matter what it is in terms of what it could become. Anything can become anything. That's an absurd way of doing it, and there's also no way to follow it. And this is the sort of thing that the Department of Justice for Kamala Harris and Joe Biden have tried to get away with, using the ATF as a means for additional gun control laws without going to Congress, and it has blown up in their face. So we're going to see whether or not the Supreme Court talks about these letters during the oral argument on October 8th. But I can tell you right here and right now, there's no doubt in my mind that the Solicitor General's office is entirely embarrassed and upset that they messed this up 6 ways to Sunday. This is extremely embarrassing, and most importantly, from our point of view in terms of the Second Amendment, it's going to kill their credibility, because if they got such a material fact wrong in their submission to the Supreme Court of the United States, I can assure you the justices will be asking themselves, what else did the ATF and this administration get wrong in any other part of the case? And can we really trust anything they're telling us at this point? Well, we'll see what happens. All right, folks, so there you have it. Hope you enjoyed today's episode of the Four Boxes Diner. Make sure you follow me on X. We have over 18,000 followers on X at Four Boxes Diner. A lot more information over there. And make sure you subscribe and like this video. We're still trying to grow the channel. We're working hard to get it bigger and bigger as best we can. We're very far behind everyone else, but we're working hard to try to catch up. So hopefully you'll help us do that. And again, we look forward to seeing you very soon here at the Four Boxes Diner.
Orders up. Table 2A.